But we have a great panel today presenting a book, which maybe you could show people, on war crimes in Russia's invasion of Ukraine. And so we have three presenters. Mishka Bienchik-Misala, who's a professor in political sciences and a researcher and lecturer at the Faculty of Political Science and International Studies of the University of Warsaw. And then Patrycja Grzebyk, who is Associate Professor of International Law at the University of Warsaw. And Dominika Uczkiewicz, who is the Assistant Professor of Modern History at the Pilecki Institute. So welcome everyone. And Patrycja is going to start by just giving a little bit of an introduction, and then we'll go from there.
Yes, just to let you know at the beginning, what are the origins of the book? Well, the origins are quite obvious. The invasion of Russia and the commission of widespread crimes. This inspired us just 1 year after the invasion of 2022, with the full awareness that the war was ongoing from 2014, to organize the conference in Berlin and invite scholars from the West, but also from the Central Eastern Europe for the conference. And after this conference, we decided to invite those who could devote their time and their knowledge to work with us on the book, which is divided into three parts. One part is divided to explain the roots of the war, how we understand this war, and by we, I understand that we have scholars from various states, but we wanted also to give the floor to scholars from the Central and Eastern Europe, because many times we could hear in the media so-called West-planning of what's going on in Ukraine, and we wanted to give also the voice to also Ukrainian scholars to say what is their perception, why they are stressing certain terms. For example, why the word genocide is appearing when we talk about Ukraine, and why they prefer this word. So that's just, to understand the perspective why, for example, in the whole discussion, we are not talking only about the last few years, but we are going back to the deep past. I would say that we are talking even not to the World War II, but even to the circumstances from the pre-war World War II. So that's why we have this part devoted to so-called Soviet legacy and Ruski Mir. Then we had a part devoted to the question of documentation. And in this part, you could see chapters devoted how the evidence is collected now, with the focus on electronic evidence, which is of great importance in current proceedings. But also you would find documentation of evidence from various perspectives, and this would Dominika explain, not only for the prosecution in various courts, because we are not sure whether this would really happen, but also to collect evidence, to collect testimonies, to just know the truth. And then we created the part devoted to the attempts at the time of the prosecution. And we need to be aware that these articles were submitted in 2024. We gave the chance to authors to make some corrections during vacation of 2024, if I remember well. But there are ongoing developments. And of course, during today's seminar, we would like to focus on what is new, what kind of also update we would make. However, we think that in the book you would find chapters which present the general knowledge, the general attempt, what was done at the very beginning of the invasion of 2022, and also what kind of lessons can be drawn, not only for Ukraine, but for various conflicts in which we observe the atrocities. In this book, there is also the first chapter of Mark Kramer, who was so kind to organize this workshop, and we regret that he could not be today with us, but we are very grateful to him. And I think that the good news is that I know that one copy is here shown to you, but the book was covered by the program of Routledge to have it in open access, so you can freely access it, download it, read it. So we are very happy from this, because also this is when you write about the war crimes, and also many Ukrainian lawyers who are working on this case, they would like to have access to the publication, and then this is quite expensive publication, as always with the Western publishing houses. So that's why we are extremely happy that now all those who not only want to know the history, who want to know the political circumstances, but also practitioners who really work on those cases have access to this book. And for the moment, I would stop because, yeah, I would give floor to my colleague first.
Thank you so much. So I wrote the chapter devoted to crimes, Russian crimes in Ukraine after 24 February 2022. My thesis was that Russia uses war crime as a tool of war. Generally speaking, at the University of Warsaw, we do the project devoted to Russia's wars. So I'm responsible for the question of international humanitarian law. So I did some research on crimes committed during wars in Chechnya, in Syria, and of course in Ukraine. And it is easy, unfortunately, to identify some patterns. Moreover, I also used the methodology which was somehow proposed in the resolution of the United Nations Security Council of 2008, which was devoted to the question of rape and sexual violence as a tool of war. So the resolution showed that rape, sexual violence can be used as a tool, as a means to humiliate, to terrorize the population, to advance the objectives of armed conflicts. And in this case, mainly women are treated not as a protected group, but as a kind of enemy. Groups are subjected to punishment, humiliation, subjugation, and even death. And in case of Ukraine, in my opinion, it will be one of the best evidence that because Ukraine cooperates with international organizations, with individual states which are interested in this issue. So we have quite a lot of information on violations of international law. And also it was identified by different commissions, UN Commission, OSCE Commission, the Commission of War Crimes, Crimes Against Humanity, some patterns of human rights violations were identified. Those crimes are committed in three contexts. So as a part of military campaign, there are crimes committed on occupied territories. And to be honest, there is a lack of the access to the occupied territories. So we know a lot from our discussions with refugees mainly. And there are crimes committed in prisons, camps, just speaking, detention facilities. So of course, it is the most difficult to say or to identify crimes committed as a part of military campaigns, because we don't have the access to full information. Very often we don't know what was the real objective of the campaign, but the scale suggests that, of course, that civilian objectives deliberately have been and are attacked during this war. So imagine that during the first month of the war, according to Prosecutor General's Office of Ukraine, almost 4,000 objectives, civilian objectives, had been destroyed. Only 1 month. There are some cities which are destroyed in more than 80%, as Mariupol, more than 500 buildings, highest buildings completely destroyed, and some other examples like Bakhmut, Popasna, Severodonetsk, etc., etc. What is also shocking, bombings of hospitals, schools. There are some data which you can analyze on the slide, that, for example, 3,600 educational institutions were damaged. Also from civilian population point of view, And the problem is attacking critical infrastructure, energy infrastructure. And according to international organizations, around 12 million of people suffered because of lack of the access to energy, sometimes also water, as a result of those attacks. Losses were estimated at more than $10 billion. Of course, it is also the source of refugees. Today, in Ukraine, there is 3.7 million people who are internally displaced persons, almost 7 million war refugees, especially they are in Europe. Today, many reports also say about torturing and killing of Ukrainian prisoners of war and civilians. Of course, since the beginning of the war, we've got a lot of information about torturing, especially on the occupied territories. There are special camps, so-called filtration centers. Very often adults are checked if they are patriots, Ukrainian patriots or not. So the goal for sure is to humiliate the population, to weaken morale of the whole population. Also, the huge problem is sexual violence, especially on the occupied territories. A year ago, Pilecki Institute published a report on it, and we know that this is the reason why women very often they look the opportunity to leave villages, cities, because they are afraid of the sexual abuses. Also, of course, forced deportation. According to Ukrainian government, around 19,000 children have been deported to Russia, and the whole system was built around. So children are selected, mainly from occupied territories. Those children very often are invited, for example, to summer camps. Then they don't come back to the families, or those children are selected based on their parents. So those parents who, for example, were not identified in a positive way, those concentration camps, filtration camps, are deprived of their children. So it's a huge problem. Many of them are then in different camps on the territory of Russia, in different parts of Russia. Many of them are adopted, as far as we know. And as you know, this is the reason why the International Criminal Court issued the arrest warrant against Vladimir Putin and Maria Lvova and Bielova. So in the end, maybe I will show you one case study, quite new report, which was also published by Pilecki Institute. In the framework of Pilecki Institute, there is so-called Lemkin's Center. And when the war started, the Lemkin Center started to cooperate with, send some people to Ukraine, to liberated territories. And the goal was to gather testimonies. So this is the case of so-called humanitarian corridor and the attack of Russian army against civilian vehicles. So the village Wypivka was occupied village, and 3 kilometers away there was the city Karolivka, which was still in Ukrainian hands. Many people wanted to leave Wypivka because of the whole situation. Examples of torturing, examples of robberies, rapes, etc., etc. But the Russian army organized some blockades and asked people to wait. After 24 hours, Russians came and those vehicles had to form the column, the civilian column. They were told to drive very slowly in the direction of Karolivka. And after several minutes, the shelling started. So 6 people were killed, 7 wounded, also 10 animals burned in those cars. And that is the example because, the Ukrainian army, which was around, they started the rescue operation. And it was the moment when the city, Karolivka, was attacked by the Russian army. So it is like the perfect example that the war crime was used as a tool to advance in Ukraine, to advance the objective of the war. Thank you so much.
The example Agnieszka just discussed, and I circulated printed copy of the report that is also accessible online. We do not attack civilians, the Green Corridor in Lipivka, as a trap set by the Russian occupying forces. It was just published, as said, 2 weeks ago by our colleagues from the Raphael Lemkin Center for Documenting Russian Crimes. And this is one of the initiatives of working groups that were established immediately after the Russian invasion, full-scale invasion in Poland to document crimes committed in Ukraine by interviewing refugees that were in Poland, but also other European countries, but also by conducting interviews on the ground in Ukraine by persons cooperating volunteers in Ukraine. So very rich collection of material was gathered, and the report you see, and you can also access it online. Some recordings are also available, the pictures, but also some short videos are taken on the spot. The challenge of documenting crimes committed during the war in Ukraine is a very complex topic, but mainly it concerns the question how to harmonize and coordinate investigations of crimes and different documenting efforts conducted by officials, prosecutors' office, but also NGOs, civil society organizations, or research institutes or their entities, as in the case of Lemkin Center, which is in detail described in one of the book chapters. But before I will go into details about this civil society mobilization and involvement into supporting accountability efforts, I will maybe briefly discuss these tools and frameworks of cooperation of investigative powers of prosecutors' offices in Ukraine and on the international level. Already in March in 2022, we saw this strong interest and involvement of European countries, of countries from the region in documenting crimes, supporting Ukraine's Office of the Prosecutor. In March 2022, a joint investigation team under the EU agency Eurojust was created by Lithuania, Poland, and Ukraine, and later was joined also by Estonia, Latvia, Slovakia, and Romania, and later on also by the Office of the Prosecutor of the ICC. Another operational framework, another level of cooperation and support for the Ukrainian authorities, investigators, is the Atrocity Crimes Advisory Group, which was also created suddenly after the full-scale invasion by the US, by the American and British government in cooperation in the EU state. Its aim is also to advise and assist the Office of the Prosecutor General of Ukraine on the documentation and investigation and further prosecution of crimes and other atrocities. Different UN bodies and international organizations, as International Commission on Missing Persons, or the mission of experts that was established under the Moscow mechanism, are providing reports and expertise in field of specific crimes or types of victims, as in case of International Commission on Missing Persons records of persons that have been killed or are missing as a result of conduct of war. Those reports and are often supporting investigations, providing analysis of different specific types of crimes, as discussed by Agnieszka, gender-based violence, deportations of population, children, but also crimes on POWs. So on the one hand, there is this strong need to coordinate these different bodies, their skills, and on the other, in terms of providing legal advice to the Office of the Prosecutor General of Ukraine, and on the other hand, also to use the documentation collected by NGOs, civil society organizations in Ukraine and other European countries. And on the next slide, I will also show you a few examples. Some of them are also presented in the book. The already mentioned Rafał Lemkin Center for Documenting Russian Crimes in Ukraine, that is based in Warsaw, but mainly the Ukrainian organizations that are also very advanced in advocating for the question of accountability, in cooperating on international level with other organizations, but also ICC authorities and other international bodies. The Center for Civil Liberties is also presented in our book. Very interesting war crimes documentation project initiative is also conducted by the Lviv Center for Urban History that collects live history interviews of refugees in different European countries, and is focused not only on the time after the Russian invasion, but on the question how the war affected the life of the victims or witnesses to those crimes. These testimonies are collected in Ukraine by the cooperators of the Center for Urban History, but also abroad. Among different parties to this project is Polish Academy of Sciences, and hundreds of these interviews were also collected in Warsaw and other Polish cities. And what's very interesting in case of these two organizations are the methodological questions that are asked by colleagues working on this project, how to effectively collect this documentation, evidence of crimes committed on civilians, having in mind the danger of re-traumatizations of witnesses and victims, their stigma that is related to their sufferings, especially in cases of gender-based crime, sexual violence, topics that require confidentiality, but also very specific skills of the persons interviewing witnesses. So on the one hand, observing this mobilization of different NGOs, different experts, not necessarily involved in the official investigation, many practical obstacles or challenges, difficulties are arising, but are also being processed and somehow challenged by those professionals. What we also see when talking with our colleagues, when following the discussions on collecting war crimes, on data security, but also confidentiality of the information, and this very important aspect of victims' well-being, their rights perspective, and their safety is the psychological support that is needed. And here, what often is to be seen is the competence, the qualifications of colleagues working on the ground, in the NGOs, in different refugee centers, directly with the victims, have a very important skills, talk to these persons, to prevent them from the re-traumatization, to provide them the necessary support by giving testimonies on very, very fragile information, very traumatic events that occurred to them. And this knowledge on working with people affected by those type of crimes, those harm, is also important skill and new skill that is needed for the prosecutors, for the investigators, that must be also applied in the trial. So here we see this victim-oriented approach is a field where we can see strong cooperation and need for cooperation, for exchange of practices, knowledge, and experiences between different bodies, and with the aim to provide the support for survivors and witnesses. Those cases that we discuss in the book, and which also refer to many other projects, to many other initiatives concerning the documentation of war crimes, also ask the questions about data storage, information accessibility, verification of evidence, especially in cases of open source investigations, or using digital evidence that are also available online. This question is also very insightfully discussed by our colleague Hania Patrycja in one of the book chapters. Very good, and maybe the biggest, at least openly accessible project, collecting digital evidence and providing very broad collection of materials concerning specific war crimes, but also crimes locations, was the and still is the Ukraine Conflict Observatory at the Yale University, that was also supported by the US government, and provides important and comprehensive evidence concerning crimes committed in Ukraine. Next to the case studies and this practical and methodological questions, we also tried to look back in the book, in our analysis, into the history. And one case I would like just to stress is the experience and example of the United Nations War Crimes Commission. It was a commission, intergovernmental body created during the Second World War, before the Nuremberg trial in 1943, which was responsible for the collection and of war crimes evidence and documentation, and preparing cases for the post-war trials. And within 5 years of existence of this body, over 35,000 names of individuals accused of committing war crimes or international crimes were collected, with over 8,000 indictments, and those resulted in over 2,000 war crime trials after the war. And the UN War Crimes Commission, as this precedent for today's efforts to document crimes, to harmonize works of international and national authorities seems to be very important and relevant on the one hand, because it's forgotten or unknown history of accountability efforts, of cooperation of 17 allied states, but also developing common standards of collecting war crimes information, evaluating them, and also preparing charges for post-war trials. Commission's work concerned not only this investigative level, but also legal assistance and debates on the definitions of international crimes that contributed to the establishment of definitions of individual liability in the Nuremberg Charter. Crimes against peace, crimes against humanity, and war crimes were the charges discussed among those experts before August 1945, when the Nuremberg Charter was signed and gave the path to the Nuremberg trial. And why it's also important to look back at this historical example is the inclusive model of operation that UNWCC presents. The founders of this commission were the small states, the governments of occupied countries that were in London during the Second World War. It was Poland, Czechoslovakia, Belgium, who have advocated for the creation of international criminal justice, of cooperation of states aiming at effective prosecution of perpetrators, long before the London Agreement was issued. But those smaller countries, victim states, were not parts to the London Agreement, were not included as judges or prosecutors at the Nuremberg Tribunal, which is, as we argue and believe, is omission that that had impact on the Nuremberg trial, on the prosecution. And an example that could be followed today when trying to answer to the question how effectively try crimes committed, international crimes committed in Ukraine. So by including the Ukrainian voice, the perspective of affected country. That would be from me.
Thank you.
And to build on what just Dominika said, we are stressing this role of United Nations War Crimes Commission and the whole preparations for the Nuremberg process, because it gives a lot of hope. Having in mind that the first declarations concerning, the need to prosecute crimes were already issued in 1939, and it took, 6 years to even have an agreement on the Nuremberg Tribunal, it shows that it really takes time, even if you have a joint will to prosecute criminals. Also, what could be quite surprising is that when you look at the countries of the Central and Eastern Europe, you could notice that in their criminal codes, their provisions concerning war crimes, concerning crime of aggression, they are not shaped usually in accordance with the International Criminal Court statute, but they are rather shaped in accordance with the Nuremberg Charter. So those states are more attached to the Nuremberg content, I would say. So that's why, for example, just recently we've heard from prosecutors in Poland that as they know that the involvement of the ICC is not possible, for example, in case of the crime of aggression, perhaps we need to look at the history, at the practice of the Nuremberg Tribunal, of the UNWCC, because this could give us a joint, a common ground. Also having in mind that this Nuremberg standard is also accepted by Russia, as Russia was, of course, one of the co-founder of the Nuremberg Tribunal, and also have its own criminal code shaped in accordance with the Nuremberg Charter and not necessarily with the Rome Statute. So as I told you at the very beginning, our authors were asked to wonder for the moment why those crimes are committed, what are their roots, and they gave different answers. We can agree with them, we can disagree, but at least they give us their perspective, what they think we should focus on. Well, they do stress the question of the Soviet legacy, the fact that we didn't have the Nuremberg process for the communists, and we have this culture of impunity reigning for decades, that we have mass atrocities never prosecuted or never even admitted by Russia as the successor of the Soviet Union, that this impunity builds certain culture. It also means that Russia uses the same techniques like Soviet Union did, that they have a huge propaganda, they have huge misinformation process. Agnieszka just mentioned arrest warrants against Vladimir Putin and Bielova, but it's hard to not notice that immediately after the issuance of arrest warrants by the ICC, the meeting in the Security Council in Area Forum was organized, in which Bielova took part. So this means, we can observe how different reasons are presented by the propaganda to justify or to blame the other side of the conflict. We also noticed with Agnieszka, and Agnieszka also worked recently on the different narratives which is used to justify crimes, that of course blaming the other side is one thing, and Russia usually refers to law a lot. They use legal justification for various reasons, and they do not undermine in the general principles of international law. They just claim that the situation is different. Somebody did the crime was committed by somebody else, or that somebody abused its role as a protected person. We also have a chapter in our book which talks about a huge problem of militarization of the society, the way the young people are educated in Russia, the different kinds of formation in which they are trained, they are militarized, and they are prepared for the war, which also has impact on the behavior of the future soldiers. Agnieszka also mentioned the problem of deportations of children. We need to remember that, for example, Crimea is occupied since 2014, and we know already that those children which were abducted in Crimea or in other occupied territories and are now adults, they are used in the Russian army, so they are fighting with their own nation. In our book, we also deal with this potential genocidal intent. And we, in principle, as lawyers, we are suspecting, we are quite cautious when somebody raises the question of genocide, because you need to prove this special intention to destroy the nation as a whole or in part, which is very hard to be proven. However, very popular recently, especially in International Court of Justice. I've just seen the announcement of the International Court of Justice that Sudan had just filed the case against Emirates. So you know that this genocide convention is used now a lot in different contexts. However, in our book, you could see how authors, they remind us about Holodomor, about different actions against Ukraine, about different statements made against Ukrainians, statements which undermine their identity. And if you combine all those crimes which were just described by Professor Bieńczyk-Misala with also the mass evidence of the destruction of cultural goods, of the attack against culture, you could be persuaded that the aim of those crimes could be destruction of the identity of Ukrainians and of Ukrainians as such. And of course, we are persuaded that one of the narrative which we can use to explain this war is that this war is another picture of the imperial war, and the war which could be considered in terms of recolonization, that Ukraine is considered as a territory which must be controlled by Russia in one or another way, and that they don't treat that deserves sovereignty, but it must be recolonized by Russia. And I think that this argument is very important also to build a bridge of understanding with the states of so-called Global South, just to explain them that this is not another war of Europe, of war of the West, but we really have something in common, that in Central Eastern Europe you have many states which were subjugated to domination, which were somehow colonized, and now we could observe this attempt to recolonize those states. What kind of challenges to prosecution we observe? I must say that, yes, we've heard about ICC. We know that there are now 6 arrest warrants issued against Russian nationals in the International Criminal Court, but we have extreme problems concerning ICC. ICC doesn't have jurisdiction over the crime of aggression in case of Ukraine. The only possibility to engage ICC would be the referral by the Security Council, which will never happen. So the crime of aggression is excluded from the jurisdiction of the ICC. We also know from the experience that ICC can deal only with few cases. The fact that we already have 6 arrest warrants is quite impressive in comparison to other situations which are dealt by the International Criminal Court. And also we are fully aware that in order to proceed with those investigations, to prosecute those people, we need cooperation with states and cooperation in particular with Russia, for which we cannot count at this moment. And if you add the very recent problems of the ICC, because Vladimir Putin is not the only head of the state, the high official who is on prosecutorial radar of the ICC, but we have also arrest warrant, for example, against Netanyahu, which triggered United States to impose first sanctions against the ICC. We see that this institution is attacked recently, which means that this would also have impact on investigation of crimes concerning Ukraine. So what about crime of aggression? Because, of course, for Ukrainians, this is one of the major issues which needs to be dealt. And we also see very great similarity with the Nuremberg process, because in Nuremberg process also we had this maybe too much focus on the crime of aggression as such in comparison to other atrocities. We could see tremendous efforts to do something about crime of aggression. The problem is that national courts of Ukraine already do prosecute people for the crime of aggression and even sentence soldiers for the crime of aggression, which was very much criticized by those who believe that crime of aggression is a crime of leaders. And that's why the representatives of Ukraine were engaged in the negotiations of the Special Tribunal for the Crime of Aggression, the negotiations in which dozens of states are taking part, and negotiations which are I would say extremely difficult. Even if you hear announcement, recently we hear announcement in Brussels, the agreement was achieved, we are, almost we have it. No, it's not so beautiful. We know that there is a huge disagreement because, the main point to negotiate this tribunal was that we would have international tribunal which would be able to prosecute Troika. So those who have the highest positions in the Russian state. But in those negotiations, we have states which are extremely hostile to the idea of prosecution of the high officials, including, for example, United States. So they are taking part in negotiations, but they are blocking any possibility to prosecute Troika. Having in mind the changes of the situations which we observe, we could see that in those negotiations, Ukraine and also other states, because other states who are supporting Ukraine, they will not do anything against will of Ukraine. If Ukraine resigns from something, okay, we need to deal with it. Okay, this is their decision. However, according to the recent negotiations, we could observe that that Ukraine is willing to resign from the prosecution of Troika if this is the condition to establish special tribunal for the crime of aggression. It's still on the table, but there is openness for the negotiations. But we see that even if you take a step back, then there are another pressure. Okay, so now maybe you will not prosecute Troika, but maybe other high officials also should be excluded. And then the negotiators from other states are quite devastated because we invested almost 3 years of negotiations, and at the end we could receive tribunal which could do almost the same what Ukrainian courts are doing. Yeah, so this is our perception. Of course, you could hear about the huge international center for the prosecution of the crime of aggression against Ukraine, established in The Hague. It sounds nice. It sounds like nice center to collect evidence. But if you take into account that, okay, there was a will in many states, including Poland, to gather evidence. But it was mentioned by my colleagues, those prosecutors are not prepared. They don't have enough knowledge. They are just learning, how to do it. And all of them, they collect evidence according to their own national rules. So you don't have a common procedure to do it. We don't have, we count on artificial intelligence, which help us to translate different things to speed up the whole process. However, Dominika just mentioned, sometimes you have very confidential, very fragile information, which you want to protect. So this is extremely difficult, and we could hear rather bitter statements concerning the achievements of the center, which is it's like preparatory step for the works of the Special Tribunal for the Crime of Aggression. The only thing which was agreed is, okay, we understand that probably we are unable to arrest anyone from Russia concerning crime of aggression, but at least we could agree that in absentia, we could confirm some charges, so at least to do something, to announce. Because also, we need to be aware that the documentation of the crimes, collection of evidence, not necessarily will end in the sentencing of people, but even announcement of the charges, issuance of arrest warrants gives some satisfaction to the victims. Of course, there are national courts which announce that they open investigation, and then they are not really. They don't know what to do with this, statements, because they collect evidence, but people are not on their territory, so they cannot proceed with those proceedings. But I think that what is worth stressing that some states like Poland, they didn't open those investigations based on so-called universal jurisdiction, but they opened this based on protective jurisdiction. Why? Because they were stressing that the war in Ukraine is not considered as a problem between Russia and Ukraine, but as a war against international security. So it should be of interest for various states. And of course, prosecutors are claiming, well, what about cooperation? We are collecting evidence, but maybe we should divide tasks. Why we should focus on the same, and then who would proceed with this? Many prosecutors in third states, they say, okay, we collect evidence, but just to support Ukraine. We are not willing to have our own investigation. So there are some misunderstandings, although recently, and I'm talking about the discussions which took place within the last few weeks, at least this cooperation within joint investigative team, which Dominika described, works quite well. And ICC shared the information, what is their strategy and what kind of situation they want to focus on. We know that first was deportation of children. We know there are attacks against civilian objects. And there is a third case prepared, and probably the arrest warrants will be issued. And almost certain is that they would focus on the prosecution of crimes committed in various detention centers, prisons, filtration camps, and so on. What are the further challenges? And also to stress, I remember when we received reviews for these books, we were accused, okay, you are focusing only on the crimes against Ukrainians, so you are biased. Why you are not talking about crimes against Russians? And we stressed in many chapters, we are interested in prosecution of all crimes, but we cannot deny the fact that in case of Russian crimes, we could observe that those crimes are committed in widespread and systematic manner. So that's why the focus is on Russian crimes, but we do stress that if there are any violations of international humanitarian law, which could be classified as war crimes, of course, they must be prosecuted. And also we referred to the reports of international organizations, which Agnieszka mentioned, which also notice some violations on behalf of Ukraine, but mainly they are stressing the scope of Russian crimes. Agnieszka already told us about the problem that we would love to know. We know that crimes are committed in occupied territories. You could understand the fear of Ukrainians, but also of other states from Central Eastern Europe concerning the war. We know that if Russian army is coming to your territory, crimes will happen. It's for Satan. Yeah, that we know that people are immediately deported, that people are killed, that are raped. So that's why this focus on crimes to show the scope is so important, to say we cannot lose we cannot lose those territories, we cannot lose any new territories, because we know what would happen to people. It's not only about territory and sovereignty, it's about the protection of people. What about them? Yeah, and I did mention the problem with arresting criminals, although we can feel some kind of satisfaction that at least those against whom we have arrest warrants, they don't feel safe to travel through the whole world. Yeah, we know that this is extreme limitation. Yes, you could hear, for example, about the visit of Putin in Mongolia. And then what about Mongolia? They are party to the ICC, so why they invited Vladimir Putin and welcomed here? But at the same time, I think it must be stressed that Moldova was afterwards engaged in the process. They were engaged in the consultation with the ICC and tried to explain their special situation. That one thing is to be responsible for the arresting people, for the investigation, but another thing is what to do when the head of the state is coming with the visit to you, and you don't want to be involved in the war, for example. And I think that we need to stress that we have also a fantastic chapter in our book which deals with the fairness of ongoing investigations, of ongoing processes in Ukraine. There are many problems identified there, which we know that they were not solved. And what we could also hear from our within our consultations is that as there is such a huge demand to prosecute somebody, but you are not able to do it because you cannot arrest those people. What is particularly disturbing that sometimes the focus of the investigators is on so-called collaborators. And sometimes people who just stayed in the occupied territories try to help people who stayed there. There are instances they are accused for the collaboration and they are classified as a prosecution of war crimes. So we need to be aware of these circumstances. And we know also this from history, because we know that after World War II, the major focus on various communist states at that time was not on war crimes, but on the collaborators. And that's why we cannot believe in those statistics after World War II. And I think that we need to be very cautious about statistics concerning conflict which we have now. So I would end at this moment, ready for your questions, of course, if Dmitry allows.
Yes, so we have about half an hour and welcome questions or comments. Yeah. Oh, and please introduce yourself.
Martin Skopranks, I'm a visiting scholar at the Davis Center. Probably. I want to ask about these institutions that document crimes. They also document, you mentioned at the very end of your talk, collaborationism. Do they document the cases of collaborationism also?
As far as we know, no. As far as we know, no. They don't deal with this, because collaboration as such is not a war crime. However, if you would classify sometimes a kind of collaboration as assistance in war crimes, then yes, yeah. But I think it's also the question of the politics somehow. You don't want to reveal the scale sometimes of collaboration towards the international institutions. And also we know that some crimes could not be committed without the cooperation of people who are living there. Like, for example, we know that there were those lists of people who are supposed to be executed. So there need to be some kind of assistance in war crimes. So if we talk about this kind of assistance, yes.
For example, this very tragic case of Kroza, where 51, almost all the village was actually wiped out after the attack, which was actually allegedly due to two brothers who lived there and who actually betrayed and pointed to.
As far as
it's also the question of methodology and focus of each center. And we are not experts for all the aims, but even knowing the there are so different goals of collecting those testimonies. They don't have to be used as trial materials. Yes, they don't need to be admitted, or at least in view of interviews of organizations collecting this histories, this testimonies. It not necessarily must be used as trial material. There are projects or initiatives just to capture the experience of war, and I believe that that would be questioned to our colleagues from the Institute for Philosophy and Sociology of the Polish Academy of Sciences, who are involved in this life histories testimonies project that is not only focused on the invasion, but invasion and post-invasion experience in the context of the whole life, how it impacted life of particular individuals. And I can imagine there are more initiatives and different collections of testimonies that may include information of acts of collaboration. As far as I know from the colleagues who were working with refugees in Poland from the Lemkin Center in Warsaw, there were also interviews concerning the collaborations or their, well, Ukrainians somehow involved or having knowledge of certain crimes. From what I heard from colleagues interviewing those refugees, the willingness or ability of the survivors, refugees, to talk about those crimes or details concerning these types of involvement in crimes committed during the war is different, can be different than to giving details on perpetrators from the Russian troops. But even in those cases, there is a fear of what will happen to the family of the witnesses of wars or victims who escaped Ukraine. Giving testimonies can also cause fear of life of the families, relatives, friends who are still in the occupied territory. So it's not simple to collect this kind of information, even in case of crimes committed by Russian troops. And I believe in crimes committed by Ukrainians or giving accounts on some types of involvement of Ukrainian people may be also different from this type of motivations and grounds.
And we need to be aware that if you have reports of the international organizations, usually they don't make statements concerning particular names. Yeah, if we talk about prosecution of Ukrainians, usually these are Ukrainian courts which are particularly interested in prosecution of them. It is also interesting, I must say, that when we would have tribunals to prosecute crime of aggression, because, for example, occupation of territories of the eastern territories of Ukraine, some of the high officials of the occupying powers are of Ukrainian nationality. So this would be interesting, whether they would be covered by the prosecution of the potential tribunal. And also just to build on what Dominika said, we've heard also from the interviewers that those who were coming to Poland, and of course, the evidence were collected in many states, but having in mind that the main influx of war refugees went through Poland, that's why I think that this is a huge amount of evidence to which we can refer. And they were stressing that they were not willing to talk and to testify towards Ukrainian prosecutors because they didn't trust them. And they didn't trust that the evidence which will be collected there in Ukraine will not be soon or later in the hands of Russia. And then, so that's when they were coming to Poland. Still, they were very cautious because the family was staying in Ukraine. And what was particularly striking for me, who was willing to talk? Those who were living in those villages, cities who were bombarded, the people who felt that they will not survive the particular situation. And that's why they were willing to film, to testify immediately via internet, just to tell what's going on, because they didn't want that this evidence died with them. Yeah, but I must say that this mistrust is there. And also you need to say, I need to stress, even if I look at Poland, there were many various centers and organizations which wanted to collect evidence. Some of them, we know that they were in the past financed by Russia. And that's why this was a huge issue, that there was there was a huge disinformation, and there was no strategy how to guide those who want to testify, with whom they should talk, that not necessarily with the private organization with various ties to Russia, which was not very safe for them. And another issue, if there were people who were willing to speak and they were talking with one organization or with another, and you would like to use their testimonies in the court, with every talk, it's natural. You add something, you change some details, but this can be used against you in the process. So that's why at a certain moment we will say, okay, maybe let's limit the scope of collection of evidence by different foundations, organizations, because this could ruin the future proceedings in the courts.
But this is also the perfect case for Ukrainian prosecutors. And as far as I know, until 23rd December last year, 41 judgments were announced by Ukrainian courts, and there were also some concerning collaboration question. So it's easier for them than for international institutions to deal with such escalations.
Tom Johnson, UMass Boston. I'd like to take 60 seconds, if I may, and with a comment and a question. I'm not a scholar of international law. I'm a historian who studies the history of the wars where the crimes and atrocities are committed, and hopefully the peace building efforts afterwards. But from my perspective, history weighs very heavily on the current war, especially Soviet history. When I heard of Bucha, my first thought was Nemmersdorf in East Prussia, an early Soviet army atrocities on the soil of the Third Reich. When I heard about Olenivka, it evokes memories of the West Ukrainian prison massacres of 1941. And then the whole war with the Muscovites claiming that they're fighting Nazis and fascists. I mean, they're trying to reprise the whole Great Patriotic War. So that's my historian's perspective. So here's the question for you. And maybe you could go back to the screen with all the organizations that are investigating there. This is really helpful. I really appreciate seeing this. But I've thought for a long time that if it isn't already, this war will probably become the best documented war in history. And it's not just due to the efforts of the institutions and the professionals. Almost anybody with a cell phone is capable of documenting war crimes and atrocities. So there's a huge mountain of evidence being generated by, but in a less systematic way by people who are not professional investigators. So the question is, how do the pros take this mountain of evidence and integrate it into a more systematic, formal and institutional inquiries? Thank you very much.
Mm-hmm. Well, just about your comment, we do observe, when I'm talking about this fear concerning the crimes which are ongoing and which could happen, and I must say that this fear is also in Poland, that Polish people are very afraid of the war because they remember what happened during World War II, and they are observing what's going in Ukraine. And this rhetoric which is used by Russia, this, how to say it, those Nazis, fascists, the words which refer to World War II and which even augments the whole fear because, it opens different windows in your head. You are right that there was a huge amount of evidence, and that's why there is, but I must say that in our talks with prosecutors, they say, okay, we collect this evidence. There's a lot. Sometimes they are not prepared how to deal with this electronic evidence, how to, for example, verify the value, whether they are where they are not fake, and whether they can be used in the court. And this is the process of consultation between them, and they are not prepared to do it. They are completely unprepared to do it. And that's why they are saying, okay, it's too much. There are too much evidence collected on various issues. Let's focus on something. And that's why within the joint investigative team, within the discussion with the ICC, they try to identify different cases and say, okay, this case, who is interested? Oh, you Ukrainians. Okay, so let's leave it to you. We will give you whatever we have. Yeah, ICC is saying that they want to deal with only this type of crimes because they want to prioritize something, yeah, and to flag something. So let's give all we have to the ICC. Yeah. So now we could observe. Maybe better. We would see what will be the results, but some kind of division of tasks and sending what you have to the particular people. However, I must also stress one more thing. Usually, if you want to prove something, if you want to really prove the case in the court, you need to rely on intelligence. And so you are contacting your own intelligence agencies. And they are saying, no, we don't want to cooperate. Because if we have informator in particular territory, we don't want to burn this person. No, we don't want to lose this person. So sorry, I know that you are focusing on some crime, but this cooperation with this person is too important for us to reveal him to the court, the identity. So prosecutors are complaining all the time that they would count on some on the data collected by intelligence agencies, but you don't have working cooperation between various intelligence agencies from various states, and you don't have even good cooperation between prosecutors and your own national intelligence agency. So you have a lot of evidence, but I would say that still we need to work on the cooperation. And also what I could see that the intelligence agencies, agents, prosecutors, they say at least the whole process which we have now, it helps us because we establish new forms of the cooperation and we are using them for other purposes, not necessarily for war crimes, but to, for example, to deal with the problem of terrorism, which do happen now in relation with the war.
Yes, I would like to have 3 comments. I agree with you that in this conflict, especially the historical context is extremely important. And Ukrainians, especially, they talk about Holodomor. So the situation that Stalin tried to eliminate the whole group by the famine. We don't know the exact data, more than 3 million people died because of the famine. And taking into account that today, like the nationhood of Ukraine is put into the question, Putin, other Russian officials, they very often repeated that they are Nazis, not Ukrainians, there is no Ukrainian nation, etc., etc. For my Ukrainian colleagues, it is just the next stage to eliminate the whole state. And also, like history shows that committed crimes in the Soviet and also Russian army is perceived very often as a kind of loyalty towards the state. Very often those Russian soldiers who committed crimes, for example, in Chechnya, it was for them the way of advancement in the army. Then they were sent to Syria. They were responsible for additional for crimes as well. And then they were also in Ukraine, engaged in Ukraine. I was in Bucha last year, and people living there, they are really thankful that we are interested in this issue. They want to share their stories, and that's why I'm not so worried that we do have, too many evidence. It's good, for sure. We need decades to work on it. On the Ukrainian prosecutor website, there is a possibility to register the situation. And so far, around 1,600,000 cases are registered. So it's a huge work, a lot of material, but people want this, so we have no choice.
Hello, my name is Julia. I'm a law student here at Harvard. I had a question about sort of the prosecutions in other countries ongoing. Particularly, you mentioned how Poland is choosing the protective principle rather than universal jurisdiction, and I'm wondering, is besides the like very interesting rhetorical effect of the war on international security, is there any sort of practical difference between, and are other jurisdictions also starting to do this?
Thank you for this question, because I must say, I was very proud that that in my country they announced they use protective jurisdiction. At first, I know that the other states were saying, okay, why they are doing this? And in principle, there is a difference between universal and protective jurisdiction, because if you use protective jurisdiction, and as I explained to you, you are saying that this crime of aggression is also against your own security. This means that you proceed with the investigation, which aim is not to only support Ukrainian prosecutors, but you have your own independent investigation. So this would mean that we are really attaching importance to it, and we really want to have our own proceeding. Yeah, this is understanding of those who know the procedure and know the doctrine. Unfortunately, this was not the case with the Polish prosecutors, who opened this investigation, but they were not aware that their job is not only support Ukrainians, but that they need to focus on their own investigations. Now, but of course, maybe this misunderstanding at the very beginning was not so, I would say, dangerous, having in mind that still it took time to collect evidence. It took time also to learn prosecutors to deal with those crimes, because, for example, in case of Polish prosecutors, they didn't have any experience in dealing with international crimes. And just to give you the example, the main prosecutor who is dealing with the crime of aggression in Poland, he said, okay, this is just one of the tasks with which I'm dealing. And I'm sorry, this week I had to be in the court 3 times because I was dealing with some old robbery from the 90s in the shop. And this is the crime for which I would be responsible, towards my supervisors, whether I dealt with this correctly or not. They will not worry about crime of aggression, but they would say, what about this old crime which you need to investigate concerning robbery? And he said, I'm sorry, I don't have time and I need to still learn how to do it properly. And what can I do if I know that I don't have those people on the territory of Poland? So if you don't have a real perspective to prosecute somebody, your will is quite weak, I would say. However, and I think that civil societies, organizations, they pressure, and also pressure of victims who are living in Poland, and they are asking the questions, what are the results? This is a kind of impulse to do something. And now what we could observe is that there is an attempt to change the Polish law to this extent that to be able to do more as on this pre-trial stage. So to perhaps confirm some charges, which was not possible without the presence of the person so far. But now when we see how this works in case of this conflict, there is a will to change also Polish procedure to be better prepared to investigate those crimes. And there are voices now for months putting a huge pressure on our Minister of Justice that this cannot be randomly appointed prosecutors to this case, but you need to have a kind of special department which is dealing with the international crimes, and not only with international crimes in Ukraine. There are also crimes committed in other conflicts in which Polish people are killed, and they need to cooperate together. Yeah, so we will see whether we will observe this change. And also to answer more your question, because you asked what about other states, how they react to this announcement about protective jurisdiction. Yes, I've heard, for example, from like Austria and other states, they say that they also consider whether they should do it, because it really depends on your own national procedure, what according to your national procedure rules you can do, depending which basis you will use to open the investigation. So now they didn't consider protective jurisdiction, but with Polish explanation, now they did consider that this could be useful for them. So I think, well, at least we have some new tendency that not necessarily we just need to refer to universal jurisdiction, but we have also other options.
My name is Tamar. I'm from Georgia, and for professional and personal reasons, this work is really close to my heart. And thank you for undertaking this very, very important work. My question concerns the challenges that you depicted in the documentation, then how they translate into litigation as such, be it before the ICC or the Strasbourg Court or any other international court of tribunal that might enter the picture. Considering all these challenges, coupled with Russia's non-cooperation with international bodies and institutions, and not having access to the occupied territories or other territories, I wonder what might be the counterbalance on the part of the international judicial system as such, whether their role is increasing, whether they should be more flexible in terms of admissibility of evidence, shifting burdens of proof. What are the findings of the contributors in that regard? How international rule of law deals with the Russian attempts to distort the whole system and international rule of law from the strategic litigation perspective?
Good question. And also you are touching other proceedings which we flagged in our introduction. Well, concerning criminal prosecution, I see that prosecutors are very attached to the old rules, yeah, and they want to build strong cases. And especially you can understand it when, for example, in the case of the ICC, so far you almost have the same number of conviction and finding people innocent. So the prosecutor wants to really now build a good case to not lose another case in the court. I would love to observe what would happen with not necessarily with Belova and Putin, because I think it's quite obvious. However, with those other cases related with the attacks against civilian infrastructure, having in mind that this is this type of war crimes which Agnieszka identified at the very beginning in the when you have this military operation, because it's very hard to prove that you really attacked civilian objects and not military objectives which you could attack because they were used or the location turned them into military objectives. So I must say that I'm also curious how the ICC would deal with it and what kind of evidence it would use, but we don't have so far. We could refer only to the practice of the International Criminal Tribunal for the former Yugoslavia and the cases which focused on the, for example, bombardment of the cities. Yeah, so to this we can refer. Yeah. But we will see how the court would deal with these new types of evidence, the satellite pictures, the electronic, the evidence collected by individuals on their mobiles and so on. We will see, I would say. But you are touching also another problem, because you talked about strategic litigation and you did mention, for example, European Court of Human Rights, and I would like to mention International Court of Justice. And here we have interesting case, two cases we had initiated by Ukraine against Russia, and one of them was based on the Genocide Convention. And this case is particularly interesting because you have the biggest number of states intervening in this case. And I can tell you what is the problem now. Those states which wanted to intervene it, they did submit their interventions usually in July of the previous year. Now, in November of the 2024, Russia submitted the counter memorial with counterclaims, but only Ukraine has access to it. All those more than 30 states which wanted to respond, to assess it, they don't have access to the documentation because of the procedural rules of the ICJ. And it could be that we would wait, few more months to be able to read those thousands of pages which were presented by Russia. So, and why I'm mentioning this? Because we did focus on the collection of evidence by Ukrainians or organizations focusing on crimes against Ukrainians. But I would love to also see how Russia approached collection of evidence to prove the alleged genocide against the Russian-speaking population. And this, but I think this is the development which we could observe. Yeah, so I don't have a perfect answer to your question because we don't have this practice which we could analyze. Yeah.
Thank you so much for presenting this book. My name is Grzebyk. I teach Russian-Ukrainian. And I teach words, and words are very important also for legal issues. So I pay attention that the title of the book is Enforced Conflict. And then in the book, there is Ukraine war, and Russian war, and conflict. What is your stance on that? It is very important for Ukrainians to state that it is war, not to share also Russia's propaganda that it is some kind of conflict. So should elaborate.
We are not carrying Russian propaganda in this book.
Russia is not happy.
It's editor's intervention, and after discussions with authors, English-speaking colleagues, we agreed to this title, although the original title we are working with was Russian-Ukrainian War, Challenges to the Documentation and Prosecution.
But just yes, we struggled with, because we had another title for this book. However, there was a huge opposition of the publishing house, and that's why there's a compromise formula which we picked. Also because it could be to some extent also misleading, because you hear here and war crimes, while in the book you will find about genocide, crime against humanity, and other violations. But I must say that when I know also what is the Ukrainian approach to the terminology, and I know how important it is for them. However, if you look from the perspective of international humanitarian law and international criminal law, when we talk about war crimes, there is nothing wrong about the concept of the armed conflict, that it is in light of international humanitarian law, this is interstate armed conflict between Russia and Ukraine. And the title doesn't unfortunately reveal who is aggressor, it just stresses the legal state. It is international armed conflict between those two states. However, within the book, you will see that there is a lot about who started the war, for what reasons, who is an aggressor, and who should be responsible for this.
What was the reasoning behind changing war into conflict of the publishing house?
Intervention of the publishing house. And you could, of course, expect, that, it's videotaped, so I don't know whether I can reveal everything and, to be very public, but you are fully aware that it's not easy to publish quickly in the West book, in which you have many scholars from the Central and Eastern Europe. And we heard a lot of criticism concerning focusing on various issues. So sometimes we think that the title is not inappropriate in the legal terms. It could be, I know that Ukrainians could be dissatisfied that it should be war here, or aggression, invasion, but we also didn't want to use a word invasion, because we also stressed it in the introduction. The war started in 2014. The aggression started in 2014. And from the very beginning, you have various acts of aggression. What happened in 2022 is just escalation, tremendous escalation, but this is still the same aggression which started in 2014. That's why we've chosen the title which was acceptable for the publishing house and also acceptable for us as editors and for authors, that it's, legally speaking, it is appropriate. It is international armed conflict in which war crimes are committed.
And other international crimes, that was also the problem of this title, but
Can we ask what the original proposed title was?
Oh, they were cool.
Just out of curiosity.
I cannot cite it now properly, but I think we used word aggression, that there was, that these were crimes related with aggression of Russia against Ukraine. And then, it was reshaped a little bit.
It was clearly Russia's war on Ukraine.
But I must also stress that the reviewers, they, it was very challenging, to publish this book, because reviewers sometimes they were quite hostile towards the focus on the Russian crimes. And I spent quite a lot of time to write a huge response while we are talking about this, in what chapters you could hear about our concerns, and that this is not to say that, yes, Ukrainians are right about everything, they can do whatever. No, we do stress that if they want to prosecute crimes, they need to do it fairly, that they need to do the job, that other states which want to prosecute crimes, they are not prepared to do it. So that's why also the job must be done. And so we also were very cautious to what kind of sources we refer. There was huge work done also with the authors from Ukraine to, how to say, to, you know, when you are Ukrainians and you are working during the war and you are traumatized, it's very difficult to avoid the very, how to say, subjective emotional words. And for us as editors, we were pressured, okay, we understand you, but let's avoid some statements because this must be much more objective. And also what we wanted to stress, it's not that this book is only to be used in reference to Ukrainian conflict. This is the book which could be as a point of reference to deal with other crimes committed in other armed conflicts. So that's why we did our best to use objective language to avoid emotions, even if those emotions were extremely high, especially during the conference, you know, that it's very difficult for Ukrainians to speak about this without emotions, and we fully understand it, yeah?
Of course, I see Mark's introduction, and there's a long list, and this is just at the end of the list, and it's sad to think that the list may continue, and this will also just be another page of it.
And it was, we wanted to publish it also as soon as possible to give some food for thought, to alert people. And, you know, even, you know, you remember maybe those statements made, Ukraine will ratify Rome Statute. No, they are not ratifying, still they are waiting, you know, and we were observing all the situation all the time. We were in Anton Kornevich, who is the main agent of Ukraine in ICJ and in the discussion about special tribunal for the crime of aggression and so on. He published his chapter to describe from his perspective how those negotiations were ongoing. And each time when we were in touch, I was asking, when will you ratify the Rome Statute? What's going on? What is the problem? And I felt very sorry for him because he had to answer to those questions many times, but there was some political obstacles to do it. So that's why in the introduction at the very last, I knew that they would ratify it very soon. We've heard about this declaration which they wanted to submit at the same time. So we said, okay, we are going in this direction. And that's why we tried to write our introduction in a safe way to mark that they want to ratify, but we were not pretty sure whether this would really happen. But fortunately, this happened in October 2024, which I think is extremely good signal. And also just to mention one more thing. This what's going on in Ukraine, the scope of atrocities, is not, and to show you the broader perspective, it's extremely important for other works. Like, for example, in July this year, you would have the special conference devoted to the amendments on the crime of aggression within the Rome Statute of the International Criminal Court. And there are states, like, for example, Denmark, which just ratified the amendments of the crime of aggression, and they said, we didn't think about it, but this war just revealed that it is necessary, that we need to do it because we are afraid. We use it as a tool to protect ourselves and to not be in the same situation like in Ukraine, that we are attacked, that we are not able to prosecute in the ICC the crime of aggression. So now there will be negotiations if some other states would follow this route, but I think it's extremely important. And to stress the whole discussion on in other areas, you have huge discussions within the International Law Commission concerning what about immunities of the state officials, and what's going on in those proceedings in Ukraine is used as argument, you know, also in those discussions.
Very important. Thank you.
If I may add something.
Yeah, okay.
Let's remember that it is continued. Like every day, people die in Ukraine. And maybe you have heard that yesterday there was an attack on the hotel and several people died, several people were wounded. And it was like I was like additionally shocked because there were some humanitarian volunteers living in this hotel, and they just went to the restaurant for the meal, and they survived because their rooms were completely, you know, disappeared. So every day we read such a story. So thank you for your interest and that you joined us today.
Great. Well, I'm afraid we're out of time. Thank you so much. This was very educational and I mean sad also, but I think it's important too that we know and that that the information is publicized and available, and this is a great step in that direction. So thank you very much.